The dust is now beginning to settle on that ruling out of the Privy Council last Thursday. Adidja Palmer and his co-accused cleared a significant hurdle when they had their murder convictions overturned by the UK-based court. And in many ways, the ruling struck a blow for justice and a fair trial in Jamaica. And regardless of who the appellants are, all our rights are vindicated, I think, when a court enforces, as the Privy Council did here, our constitutional rights. It's therefore more than a little strange that the vindication of those rights arose as a result of a deliberate act to corrupt the system intended to safeguard another important right we enjoy. And see, Notana, there's one aspect of the entire saga that has bothered me since I read the judgment of the law lords, and it continues to bother me. And I haven't heard much public comment on it, or much question on it. But I think it's a question that should be asked. On whose behalf was this rogue juror? His name is Livingston Kane. On whose behalf was he acting? Who was he working for? This man who was at the center of a $500,000 bribe to the entire jury, which the Privy Council found had so badly contaminated the entire panel that they say it was fatal to the convictions of Kartel and his co-accused. Who essentially so corrupted him that he was willing, according to the conversations related in the Privy Council ruling, to throw the case out the window without even a hint of care about the actual evidence. I think the quote was, "We just need to free the man them." Kane was prosecuted and sentenced to a year in prison at hard labor. And that almost seems mild considering the serious consequences wrought by his actions. But I'm wondering this morning who set him up to this plot to try to, and now history will show that he succeeded in bringing this entire matter down. Certainly at first blush. Now the Privy Council says there's no evidence linking the then defendants to Mr. Kane. Be that as it may, I think it's important to keep in mind that there was someone willing to fundamentally undermine and taint the system for reasons we can only speculate on. And it is precisely because that someone may still exist, or many someones of that inclination are still out there, that we have to plug the glaring loophole swiftly. It must become a matter of the greatest urgency. I hope the weaknesses that have been exposed and that cause the matter of jury management, those weaknesses, I hope they've caused the matter of jury management to move to the very top of the agenda of the Minister of Justice. For it would make a mockery of the entire criminal justice process if an accused person or someone acting in consort with them at some point in the future could simply pay to interfere with the jury knowing he or she will win on appeal. We should move now, as I understand the DPP intends to recommend, that the judge be empowered to carry on with a bench trial or judge alone trial where such irregularities and sinister intentions arise. But more than just plugging the loophole, I think we should ensure the Joint Select Committee tasked with reviewing the Jury Act takes a comprehensive look at the entire jury system. That committee should be clear that the right shouldn't be done away with, but should be strengthened, and I dare say enshrined in the Constitution. Jury management also must be front and center. The handling of jurors is just too lax. You've been at the Supreme Court, Tana. I'm sure you've observed. It's kind of too throwdown. For example, in my observations within the precincts of the Supreme Court on the occasions I have been assigned to cover criminal trials, I don't think I see any great care taken to prevent sinister outcomes. When jurors are allowed to freely go home, some via public transportation, and to mingle freely with the public, there is no guarantee that the oath they have taken is preserved. In fact, I dare say I would find it unbelievable if jurors who are sent home back into their communities, to their churches, civic groups, with ongoing media coverage of trials do not form opinions, either before the conclusion of evidence or based on conversations with those around them. We're a small society. And despite the best intentions, there'll be many a slip. My grandma would say between the cup and the lip. Unfortunately, these slips can be fatal to the administration of justice and the rights of not only the accused but the victims. The reality is if we are to retain and maintain the common law right to trial by jury as we should, then far greater care must be taken to ensure that these jury panels remain sterile and isolated during trials. During the cartel hearings, one of the Privy Council judges perhaps naively asked whether Jamaican jurors are not housed overnight in hotels. He was told no, not in practice. That's something I think we perhaps should give serious consideration to. There's obviously a cost implication here, and in this country where there are so many competing interests for the scarce resources, the issue may not immediately rise to the top of the list. But we must carefully consider not only the financial cost, but also the cost of continuing to have a system that runs the risk of not doing right by anyone. A system that leaves itself open to being corrupted against the interests of the victim, and a system which potentially allows criminals to pervert it in their own interests. That cost, I think, is far more consequential to the proper functioning of the society and to the rule of law. The cost of inaction in addressing that, I think, would be too great to bear. The committee should not be shy, the Joint Select Committee, in recommending bold changes which will see jurors being accorded the status that's befitting the important role they play, not only in individual trials, but also in a fundamental aspect of a free society, which is a fair and impartial trial. We must not take the obligation to provide that lightly. We must take it very seriously. And it starts with reforming jury trials. So let's get the ball rolling by shutting down potential avenues for tampering with our juries. That's the first important step. And finally, I want to spare a thought this morning for Clive Lizard Williams and his family. Mm-hmm. Because whatever Mr. Williams' antecedents were, the fact is someone murdered him. Someone killed him. Someone broke the law. And he was somebody's son. And I'm sure loved by his family members. And he deserves justice. Unfortunately, I think in our preoccupation with the celebrity, and when I say we, I mean also we in the media, with the celebrity of the accused, I think as a society, we've been too willing to overlook the fact that somebody was murdered. You know? Every victim deserves justice. And so Mr. Williams, his killer or killers, deserve to answer for their crimes. We must not forget that. That's what's on my mind.